He has already committed the petition to the Committee of Labor and Social Services. Do you think that still the issue of quorum will give you mileage in terms of this petition? Because again, you know the Speaker does not see until he is informed by the members of the House. Honorable Chim Kenyanya did not inform the Speaker or any other member who was present at that time until the moment after the petition has been tabled to the Committee of Labor. And then the bell rang, and then the procedure was followed to the conclusion.
Thank you. I now direct that that matter is left to the committee. That matter, yes.
And it is better if we responded.
Yes.
For purposes of the answer.
Yes.
Then further proceedings. Thank you, Chair, for the opportunity to respond. It doesn't matter whether the Speaker's eyes or no eyes. The question is, once it is done, at the end of the day, Chairman, it must have quorum. If it doesn't, it is our amplest view and the law, our own standing order, that such proceedings are quality, now void, and of no legal consequences at all. And the honorable thing this honorable committee can do is to ignore it and begin the process de novo. Thank you. Or afresh.
No further point of order. No further point of order, Honorable Muracha. Now it is the committee that will look at that matter. It is the duty of the committee that shall give the ruling anyway, but anyway, if you have views, I don't deny you give the views, but it's the committee that will determine the way forward.
And Chairman, we also reserve the opportunity to reply if anything affects us or the statement makes.
Let us try as much as we can not to be argumentative. Let us not try as much as we can not to be argumentative, and let's respect the chair. And any issue that you want to raise it through the chair so that we can move.
Chair, yesterday here, you had the senior counsel say that the clerk was not in office, and the clerk is not an office, just a person. But Mr. Speaker, Chair, when you turn into the first schedule broadcasting rules, the counter assembly privileges, audio and visual footage of the counter assembly proceedings shall be covered by the laws relating to the counter assembly privileges and shall be kept as part of the records of the counter assembly under the custody of the clerk of the counter assembly. When you refer to the document here that we have been given, it's been given by the answered Kisii counter assembly. We don't know whether this document is fake or a good document, because the clerk of the counter assembly is the custodian. He must sign through this document for us to prove that this document comes from the answer date. So I stand guided because I don't see the signature of the clerk since he's the custodian. Where did this document emanate from? I stand guided.
It is the singular mandate of the committee. The committee is listening keenly. We are noting everything. At this point, let us move so that we look at that issue if the issue has been raised about the authenticity, we'll see whether there is a problem with the document that is before us or not.
Point of order, Chair.
I said no further point of order.
Point of law, Chair.
We cannot move like that. I have made a ruling that...
Allow me to make an application.
I have made a ruling that we must move on. We must move on. So, because the petitioner also needs his time to respond. The side of the petitioner, you have your 1 hour.
Chair, I wish to make an application.
I have made a ruling.
An application. Let me make an application in over this. And regarding this, you make all the rulings that the way you wish, and listen to what we say. Do you know what I'm going to say? How can you make a ruling? Let us have the rules of procedure followed. Honorable members, there is a very serious concern that you cannot proceed without addressing. You are not saying it. He is saying that the document that you gave us is fake, and it has gone to the Hansard of an assembly in a republic that has a presidency, has the executive, that you supplied us with a fake document, and you see that is something which is simple, that you want to proceed. Can we have a confirmation from the committee that this document that you supplied us with at our calling is authentic in the interest of justice?
I have said clearly, Council, that is the singular...
And it's the majority.
It is the singular responsibility of this committee to handle that matter. Then we'll report to you as councils. But for now, I want us to move on.
When are you reporting to us? Remember, you are in a proceedings conditioned by a constitution. You must apply the please, Chair.
Yes.
Tell us the time you are going to get back to us on a confirmation whether the document you supplied us is fake or not. Then we proceed. Just like you told us the ruling which you have not said. We shall proceed.
I have said, and I want to repeat, that the committee has listened, right? You cannot compel the committee to give the answers as you wish, right? This committee has its own, it has its own rules and regulations. So you can't dictate what should be done by the committee, right? So I have ruled as a committee that we must move on so that we give the petitioner a chance also to respond, because he's also going to respond to what the issue that you have raised as far as the answer is concerned. He has had it. He's going to defend himself. I'm not going to give a further point of order. Let me, yes.
Point of information. Chair. Point of information, Chair.
The petitioner, it's your time. You can decide. You can decide to use less than an hour, but you will inform us if you are going to use the 1 hour or less than what has been allotted to you.
Chair, I think I will spend less than an hour in responding, and I will be very brief in my response, Chair. First, Chair, it is our submission that the PO before you only raises 3 issues on the face of it. The objectors have tried sneaking in other grounds, but they remain the 3 grounds on the face of the PO. And we humbly submit that none of those grounds meet the threshold that was set by the objectors themselves. Chair, they referred you to a case or an authority of the owners of motor vessel Lilian S on what a PO should be. And we say that what is before you fails every test, not even one. I will start from the very end, the last submissions going up to the first. You've been referred to the Hansard. Is it a basis of a PO? Zero. A PO is raised, Chair, on the presumption that the facts before you are not disputed. That is why it is on points of law only. The last issue of the Hansard is a point of fact. But to interest the objectors, I may answer them as they rightly put it. The speaker is blind. Was the issue raised after the motion or before the motion? After the motion. I'll let that rest at that. Issues of conflict of interest, very passionately submitted. Is that an issue of law? They have been thinking through evidence referring you to that. Have they raised any issue of law? Pure issues of facts. That way. My colleague Mr. Ochoki raised the issue of sub judice, and which he says is predominantly the basis of the PO. Now let us go back to sub judice, Chair, and get to know what is sub judice. I think once the committee understands what sub judice is, it will be very easy for you, Chair, to go through these motions. And sub judice in civil procedures you were referred, and I'll refer you to section 6. And I'll read it for you, Chair. It says, no court, or in this case this tribunal, shall proceed with the trial of any suit or proceeding in which the matter in issue is also directly and substantially in issue in a previously instituted suit. Now let us go to what they have submitted before you. Chair, Petition 5 was instituted on 6th of April, over a month later. That should be dead on arrival. Chair, Petition 10, 11th of April, should not even see the light of day. Chair, Petition 9. 2022. You are in luck, Chair, because they have said it was filed by my senior, Mr. Nemodi here. There is a notice of withdrawal. I don't know when they last checked that file. The matter was withdrawn way on 22nd March. I can supply them with a copy of the notice of withdrawal should they be desired. And on 22nd of March 2023, and I will use the words of my good friend Mr. Ochoki, that as long as there is no discontinuance, that is the discontinuance he was looking for. It is no longer there. Petition number 14, Chair, I have not seen it anywhere in their pleadings. I have not had sight of it myself. It is not raised anywhere on the face of their preliminary objection. I have just had it in his submissions right now. Chair, I'm going to respond to it later on. Once I have sight, I have not been supplied with it. It has been stated that they have dwelt at length on the form of a petition. That is Standing Order 198. I think that is the basis of the whole of the appeal. Is the issue of the form of a petition. That is the heading of that particular section. Is that the basis of appeal? Can that form the basis of appeal as defined by them? Cannot. But even to answer the singular issues raised by them in that particular standing order, they say that you have to declare if there are other matters similar. And what is declared? Here you have the petition. It is there in black and white. Anyone can read. They say you have to confirm that you have tried to address these issues in any other forum. My client has done that on the face of the petition. And now that they submitted very lengthily on that issue, they refer to it as the doctrine of exhaustion. Chair, no doubt, the only way to remove members of a public service board is what we are doing. That is the only way contemplated in law. What does the doctrine of exhaustion entail? It entails other ways of settling matters other than going through this process. And I will refer, Chair, when you have time, to go through Voi High Court Petition number 1 of 2020. That is Antipas Nyambo Manambo versus Governor of Taita Taveta County. Voi Petition 1 of 2020. That is Antipas Nyambo Manambo and 4 others versus Governor Taita Taveta County, Honorable Granton Samboja and another. It will take you through what happens in this principle of the doctrine of exhaustion. And they quote another case, and they set the threshold that it is imperative that where other dispute resolution mechanisms exist, you have to exhaust them. I have sat here since yesterday morning. I have not heard them tell you a single alternative dispute resolution mechanism that should have been adopted instead of this. Chair, you referred to a case of Meru Petition number 29 of 2018 by the objectors. When you have time, Chair, read that case. It says everything that they should not have done that they have done. It specifies the grounds for removal. And to distinguish that case, in that matter as opposed to this. There was no evidence tendered, and there were no grounds tendered in that particular petition. It therefore doesn't apply to you. Chair, an issue was nicked in on the jurisdiction. First, I will submit it is not any of their grounds in the PO. Secondly, I will submit that, as I have said before, this is the only forum that has the jurisdiction to do what we are doing. In fact, the objectors helped me by saying, what we are doing here, not even any court of law can do. And I agree with them. So I wonder how they turn around and say, you do not have jurisdiction. How will you Chair? They say the petition has several respondents. Chair, that is an issue of fact. I will not address it. And Chair, looking at it in totality, there is no preliminary objection before you. This is an attempt through the back door to try to argue their petition in the guise of issues of law. None has been raised. All through and through there have been issues of fact, fact, fact. And the same should accordingly fail. From me, that will be all, Chair. I give my colleague.
Just to add one reply to the very comprehensive reply made by my learned colleague. A lot of real estate was taken this morning by learned counsel for the respondent on the provisions of Article 251 of the Constitution of this Republic. In response to that point, my submission is that Article 251 is not applicable to this proceeding for the following reason. Article 251 is found in the general scheme of constitutional arrangement within Chapter 15 of the Constitution. Chapter 15 of the Constitution is self-contained in that Article 248 of the Constitution states the entities to which Chapter 15 relates. And I have in mind in particular Article 248, sub-Article 2 of the Constitution. I will not take up the committee's time in going through all those institutions, but suffice it to say that these institutions are known as the two independent offices, the Office of the Auditor General and the Auditor of the Controller of Budget, and to the Constitutional Commission that are set out in Article 248. With tremendous respect to my learned colleagues representing the respondent, the institution, the subject, the institution of which the respondents are members, is not one of those. And it is therefore my very respectful submission, therefore, that the submissions that were made in respect of the applicability of Article 251 are not applicable to this case. It is not possible for us to extend the provisions of the Constitution when it suits us. Thank you very much.
Chairman, we are still having a little difficulty on two issues. The issue of subsidies. I want to comment and confirm that we are yet to have sight of the E11 of 2022. And my colleagues have it on record, they have not supplied us with that particular copy, so we will reserve any comment in that relation.
Chair, I had reserved my, because I had said I had not had sight of the volume 1. In response to petition Baron Subjudice, in petition number 14 of 2022, which was the last in that list, Chair, the parties are not the same. The substance of the petition is not the same, so the same cannot be sub judice. The parties actually is Thompson Kerongo, Regina Human Rights Watchdog versus Kisii County Public Service Board. That is that corporate body you're told about, and Kisii County government. I heard you're told the assembly is part of it and whoever, none of this. And finally, Chair, no stay orders whatsoever have been supplied to you in any of these matters, even if anyone is active. These ones that have filed the letters, even if they fall short of the test, to prevent you from proceeding with this matter. That is all, Chair.
If I may just add something very briefly on 14, just having had sight of it, we need not give any extrinsic evidence in relation to documents on record. The prayers in that particular petition are very clear. They seek conservatory orders to stop recruitment of certain persons. That is very separate and distinct from removal from office from the persons of the County Public Service Board. Chairman, that will be all in response. Sorry.
Chairman, lastly, and to conclude, there is the objection that was taken that the petition before you this morning, this afternoon, is not supported by a verified affidavit. It's a strange objection because the document that is the verifying affidavit is then again objected. They say that it should not be on record. A verifying affidavit, really, in the constitutional dispensation that this country has been under for the last maybe 12 or 13 years, is really about content and not form. And it is my respectful submission that the position, the affidavit sworn in support of the petition, by the petition, contains, or the averment contained in paragraphs 14 and 15 of that affidavit, then render it a verifying affidavit. The petition is owned by the petitioner in those paragraphs, and the petitioner confirms that what he has stated is true. That, in my respectful understanding and submission, is all a verifying affidavit needs to do, and the affidavit which Learned Counsel for the respondent objects to then contains averments that render it a verifying affidavit. Thank you very much.
The Chairman, further to what my learned colleague Modi has presented, there was a petition that was presented by the petitioner on the 6th of March of 2023. And it's simply a 2-page document. That is a petition through the clerk that was committed to this committee. Thank you very much.
I believe you have exhausted responding to the issues that have been raised.
Yes, Chair. On our part, we have.
All right. You took almost 40 minutes. And to the side of the respondents, I give you 5 minutes if you have issues to rebut on.
We will ask for 15 minutes because of the issues that have been raised, not unless you have reason to believe that those 15 minutes are not just from our end. We feel that when you give us 15 minutes, we will be substantially covering the issue so that obliged. I'll just address 2 issues. My learned friend Choki will address 1 issue, and my friend Mr. Mokwa will finish. 5 each. Number 1, beginning with the last question. You have just been informed that other than the petition that our clients were served with and which they have responded to, there is another one which was the subject of that answer. I wish to point out and inform this honorable committee that that one, if that is the one you're prosecuting, we have never seen it. If we have never seen it, what it means, you'll have to set a date for it. Because the one which we have responded to is this one, which has been signed by the advocate. So that if there's another petition, we be served now. We be scheduled for hearing of that petition, so that we proceed. The document you are served with is this one, in the Republic of Kenya, and
can you please forward to us the document that you have?
Yes, you can have a look at it. This is what it was received by, on 8th of March 2023 by the Speaker. That's the one we were served with. The other one which you are prosecuting, we didn't know about it. We would like to look at it, have time to respond to it, and then we come back. I hope the time is not now running.
The petitioner, can you kindly show us if you have a copy of the petition? A 2-page document. 2-page. Yes. Okay, you have something to say? Okay, proceed.
Yes, that is a document we have produced, and if you look at the Hansard that my colleague has alluded to, it is the content word for word. That is in the Hansard.
From my team, I can confirm that the document that is in the hands of the petitioner, give them, and pass this one, together with the hard copy, and let them check whether they have the same document. The first 2 pages.
We wish to confirm that the first 2 pages look like the document you've given us. We further wish to confirm, therefore, whether if the other documents are part of it. Because then if they are not, we black them out, we deal with what you have. That is a consequence. Every answer has a consequence.
Council, when you say it looks like, you need to confirm whether it's
I'm not a document examiner.
or it looks like.
I'm not a document examiner. Council state behind you can tell you that I cannot examine this document with the specifics. But I'm looking at it from the naked eyes of a lawyer, that
Yes.
they look similar. Then if they look similar, let us be told what these other documents are. Because the next document also is titled Petition. It's written Petition. So that if there are 2 petitions in one, we know. If it's only the one we are canvassing, then we canvass it. If it's the other ones, we remove the document and we proceed.
That the petitioner is well placed to inform us on that.
Perhaps through you,
Yes.
I am constrained to ask you to compare my learned strength for the respondent to take this proceeding seriously. Because the initial submission from learned counsel now on the speech for the respondent was that there was a document they had never seen. That has disappeared. Learned counsel has said that it appears to be the same document. It can only appear in dreams. And most importantly, there is a response from the respondent. Perhaps the respondent's counsel could tell us what petition did they respond to. This is their response. What petition did they respond to? And that is the petition before you. Let's take this proceeding seriously so that we can move on.
Council, Honorable Chair.
Proceed. You requested for 15 minutes.
Yes.
I have listened. We have listened to what the issue that has been raised. Proceed and execute the issues that you wanted to execute within 15 minutes.
I'm kindly seeking for clarification as to which document was submitted to your committee, because the petitioners are deliberately trying to rectify mistakes through battle. Ideally, I'm requesting the committee to give us clarification as to which documents they received from the clerk or the speaker. Because if you look at the document we served upon our clients, the document, the petition, together with the annexures, will serve on 6th of March 2023, and the speaker acknowledged tabling it in the House on 8th of March 2023. That is the document served to our clients. So ideally, the 2 documents cannot be similar. This one is almost 200 pages, and the other one is 2 pages. For clarity, can the committee clarify which of the 2 documents is before the House?
What is the point of information, Honorable Richmond? Richmond, Honorable Richmond, kindly hold on, Honorable. I'm guided that you are not seated on this side as a friend, either as a committee or as a friend of the committee. So, Honorable Richmond, kindly. Honorable Richmond, and you are not an advocate. You are a friend of the committee.
Asante sana Mheshimiwa Mwenyekiti.
Honorable Richmond.
Mheshimiwa Mwenyekiti, nina jambo la muhimu ningependa kuwajulisha.
Whom are you representing?
Mheshimiwa Mwenyekiti,
whom are you representing?
Mimi niko pande ya kamati hapa. Mimi nilikuwa rafiki ya kamati na nina jambo.
I'll give you time later, Honorable Richmond.
Okay.
Or I throw you out.
Mheshimiwa, naomba msamaha lakini nina jambo la muhimu.
Nitakupa nafasi baadaye. Proceed. And before we proceed, Council, before I give direction, and I know you are about 10 minutes. The Honorable Deputy Speaker.
I just wanted to be clear on what document was tabled in the Assembly. A band of documents that you have there, the first 2 pages, were tabled in the Assembly, and you can see from the answer is clearly word by word is in the answer. Correct? Thank you.
Further, I should still ask for further clarity. What is the source of the other document? Because what's up together with the petition to the respondents? Honorable Chair, the entire document as a bundle will serve upon our clients. So I'm seeking clarity as to which document. That my other question I want to answer. Which document is for the house?
Honorable Deputy Speaker.
We want to make progress. In the counter assembly, the speaker tabled the first 2 pages, which is the petition responded to. The other documents that are attached to the bundle were forwarded to the committee. After the petition has been tabled, the other bundle of documents was forwarded to the committee by the clerk for us to be able to look at them. So what was tabled in the assembly was the first 2 pages, which is the petition that you responded to. The other documents that you find in the bundle were forwarded by the clerk to the Committee of Labor and Social Services. Thank you.
We stand guided, Deputy Speaker. So then what we're asking, yes, is that for us, for us to move forward, then these other documents also presenting themselves as a petition are not the ones we are discussing today. Is that the correct position?
Yes, Council.
Yes.
Chair, I perhaps seek your direction. Seek your direction to give guidance as to whether it is in order for council representing either of the parties to interrogate this committee. And I believe that is what is taking place. It is not the committee on trial. The committee is performing a delegated function. Clarity has been given as to the extent of the petition. The petition has been responded to. And I will say this until the cows come home. It is mischievous, having responded to a petition, to then ask what we are here for this morning. The petition has been responded to, unless that response is now being withdrawn.
On that matter, the committee will give directions on the way forward. Honorable Richmond, we are supposed to proceed. I don't know what is this issue that you want to raise. Okay.
Asante sana mwenyekiti wa kamati na washauri wakuu ambao mko hapa kwa ajili ya swala hili. Mheshimiwa mwenyekiti, kuna kitu tunaita kwenye bunge kanuni za kudumu. Kwa kweli mshauri mkuu hapa amesema ya kwamba tusije tukawa ni kama tunafanya uchunguzi kwenye kamati. Kamati hii imetungwa ama imetengenezwa kulingana na kanuni za kudumu za bunge za kata kama kaunti. Nimeona sijui mshauri mkuu Ben Kichana. Mshauri mkuu usije ukacheze ndumi la kawili hapa. Hapa tuna jambo ambalo natukera sisi. Limeletwa kwetu kama bunge ama kwenye kamati. Sisi tunalipiga msasa. Tujue ni la kweli ama ni la uongo. Ndio baadaye uamuzi utoke kwenye kamati. Lakini isije ikawe kama wewe mshauri mkuu unalielewa. Wewe unakuwa mkimbiaji wa bima. Kwa sababu kuna mambo mengi wewe umetufanyia reference katika kesi zingine. Lakini hapa ile kesi ambayo wewe umefanya hujatuletea kwa sababu yezi ikaja ikatuletea ya kwamba ni kama tunacheza.
What is the point of order, Mr. Baji?
Mheshimiwa Mwenyekiti, naomba msamaha kidogo tu nimalizie hili jambo. Kwa sababu
I'm on my chair, so the other member for Mogeka needs to take his seat. Mr. Chair, this is an honorable committee. You see, we are calmly handling our issues. My brother, my neighbor, who is a member of Kisii County Assembly, needs to know that decorum is a key concept of handling any business of the House. However much he may feel he needs to handle himself with sobriety and decorum. And we are not here, Mr. Chair, to discuss the persons outside this, what they do. We are only referring to the matters that I brought to the committee. So the Honorable Chair, you need to rule him out of order, because what he's referring is not contained in any of these articles. And also guide him that when he has a chance, he needs to conduct the way you are, calmly, and also while he's seated. Honorable members sit and enjoy the discussions. Okay. Our work is to midwife. We are listening to the petitioner and the respondents. The other members do not take sides. We want to hear, and at the end of the day, we shall determine by the reports that we shall bring. So let us not in any way bring emotions, because we are leaders, and also we represent even the advocates here. We are their leaders. So, Honorable Chair, please guide us accordingly.
Nimeelekezwa, lakini ni vile labda ndoga ilikuwa ngumu kidogo. Nilianza kusema kwamba sisi hatuchukui uamuzi wowote, kwa sababu Mheshimiwa Mwenyekiti, tafadhali nakuomba, kwa sababu hapo ujue tuko kwenye runinga live na kuna mambo hapa ambayo yanatokea sisi.
You are out of order.
Mheshimiwa Speaker,
you are out of order.
Mheshimiwa Speaker, tusije tukafanywa kama watoto sisi.
You are out of order.
Sisi
you are out of order. Take your seat. Take your seat or I throw you out. Honorable.
Mheshimiwa Mwenyekiti, hapa
you know the repercussions. You know the repercussions of the proceedings of such a kind of session. If I throw you out, you know the consequences. What is the point of order, Honorable Muracha? And before I give you on point of order, Honorable Muracha, you know, honorable members, we need to continue and save on time. We want to proceed.
Mr. Chair, I'm standing order number 86. Declaration of interest. Is the honorable member, Honorable Richmond, has any interest to do with Kichana? Can he declare interest? Which interest does he have? Because all he's raising in the House is not in the petition.
I have ruled him out of order, so we cannot proceed with the issues that he has raised.
Thank you, Chair.
My Vice Chair, can you say something? Out of order.
Thank you. Actually, I'm requesting our Christians, the honorable members, when you are given time to talk, not appear as if you are predetermined. If you do that, the Christians will have the learned friends will not feel comfortable. So I'm asking you, once you have been given time, air your views, because you don't belong to this committee. You have only come here as our visitor. And there is one thing I want to tell my honorable member who has just left work, Honorable Richmond. Remember that these are learned friends. Whatever language you use, people understand it. And remember that language divisions is not the mark of intelligence. We are learned, all of us are learned. Once you have been given time to talk, please speak your mind and don't in the sound.
Thank you. We proceed, and I want to remind you that we are on live, so you should know how to carry yourself around. Can you proceed with your 10 minutes?
Thank you, Honorable Chair. I'm shocked by the tone of Honorable Richmond, who was referring to an advocate of the High Court as something else, and it's good you ruled him out of order.
Proceed, I ruled him out of
that
order.
you withdrew the remarks, but you've given guidance. Honorable Chair, if I had my senior, Mr. Nyamobi, right, he was indicating that Article 251, and I hope he can listen to me so that he can nod or shake his head if I'm not right, or if I misquote him, that Article 251 of the Constitution is not applicable to these proceedings. I don't know whether I got him right. The reason why we refer to the committee to Article 251 is because the document served on us, save for the first two pages that have been titled Petition, there is page 40 or 55, the prayers that the petitioner is seeking. Honorable Chair, if you are to look at prayer 3 and 5, and allow me just read 5, that upon deliberations of the committee report, the Honorable Speaker do cause a vote to be taken as to whether the members are satisfied that the petition discloses a ground for removal of any or all of the respondents pursuant to Article 251(1) of the Constitution. Prayer 3 of that, of what you are being sought to do, refers to Article 251(1) of the Constitution. So that if the petitioner's lead counsel says that grounds for removal are not found in Article 251 and refers you to Article 248 of the Constitution, then we are not sure of what we are going to defend, because we've come looking at the provisions of Article 251 of the Constitution, which according to our understanding of Section 58(5) of the County Governments Act is the proper section of law to seek the removal of the respondents. So that if the petitioner's advocate is admitting that Article 251 is not applicable, then Honorable Chair and members of the committee, you actually have an easy job. You cannot rely on Article 251 when Mr. Nyamodi is on record saying it's not applicable. Finally, on the verifying affidavit, I made reference, Honorable Speaker, Honorable Chair, to Standing Order 198F, I believe. Let me just be sure so that I don't mislead the committee. I made reference to Standing Order 198 K and R and L, K and L, which talks of the petitioner referring, let me just be sure, G, reference to verifying affidavit in my earlier submissions, Honorable Chair, were made pursuant to the provisions of Standing Order 198G, which provides for the petitioner to indicate whether the issues before the committee are before a court of law. So that reference to verifying affidavit was purely to just allude to what needs to be done, indicating that it was mandatory for the petitioner to do that. Note that the verifying affidavit was necessary in the petition. Thank you very much, Honorable Chair.
Thank you, Honorable Chair. Very brief. Honorable Chair, I will begin my very brief response to concur with my brother Namodi over Article 251, under which this petition was brought. And this is what I did submit yesterday. Under these very provisions and under Section 58 of the County Government Act 2012, whereby the courts have repeatedly said, and I submitted my authorities yesterday, including the Court of Appeal at Kisii, where the committee and the county assembly do not have powers to entertain a petition brought under this, and brought the way it has been brought. These have been repeated even on a further authority, which concurs with what my brother said. Bungoma, this was in Bungoma, petition number 45, that is High Court, ERC, petition number 45 of 2017, where the Bungoma County Public Service Board and the 6 others who were members of that board were clearly brought before the court to be removed. The court said clearly that they did not, the county assembly and the committee did not have jurisdiction to entertain. This being the case, Mr. Chairman, I could submit that our petition on jurisdiction, our points of objection on jurisdiction did not come from the air. It was specifically anchored under Article 251 and Section 58 of the County Government Act. Therefore, we didn't need even to raise it, already having been raised by the petition. And my brother, the lead counsel, went ahead saying that it should be purely on what is there, on the pleading. The pleadings are assumed that they are who we are. When we are attacking them, when we are raising the objection that the same pleading, in fact, the petition offends the very provisions of the Constitution and of the County Government Act under which it has been brought. For that reason, this is very, very, very compelling point or preliminary objection, and that should be upheld by the committee, and this petition be dismissed. Now that we have more than one petition, I think chairman and the committee well versed will give guidance. And the further stated that whether the petition should have come as one, or the provisions allow that one section should go to the assembly, and another one should come to the committee, and another one should come during the proceedings hearing. That also should come out clear from the petitioner party has done what he wanted, and he said clearly yesterday that he has nothing to want. Thank you.
Chair, just 1 minute. One minute. Chair, my senior Mr. Nyamudi talked of petition number 13 of 2022, which was withdrawn. We wish to state that there is no indication before this committee that that particular petition was withdrawn. Secondly, it is said that the petition was withdrawn on the 22nd of March 2023. That if at all the same was withdrawn, it was withdrawn after the filing of this petition. Thank you.
I don't know whether you have recorded what you have said, because I consulted. Thank you very much, wonderful Kenyans, for having taken your time to sit before this committee and to listen keenly to the petition that is before us. In such gatherings, you can see people people's feelings going high, but it's very normal. It is very normal. We are still brothers and sisters, and at the end of the day, justice shall be dispensed. I now direct that we break for lunch. We come back at exactly 2:30 for further directions. I also want to remind the respondent that you promised to give us the petition E11 of 2022. So if you're at a position, please kindly do it at 2, so that we can have a look at it before we proceed with the business as from 2:30. Thank you very much.
Chair, thank you for that remark. I want whether you indicate the ruling of your promise.
I have said I'll give directions when we come up to that.
Then
because we are going to consult.
And then number 2, you had indicated that you have to make a decision on the whatever of the contract going by the
I will do that.
And then number 3, you also to make as a committee deliberation on all the other documents in the petition other than the first 2 things.
Can you come up again?
You will say,
yes,
as a committee, you are going to make a deliberation,
yes,
on all the other documents,
yes,
in the petition,
yes,
other than the 2 pages,
yes,
that's what we
yes.
So we are expecting
yes,
your communication on those issues.
Yes, we'll address all those issues as from 2 to that. Thank you very much. Enjoy your lunch. Feel free. What was your? I want the first item.
The first item is the ruling you promised.
Yes.
Whether you are going to give it to us, that is on yesterday's ruling.
Yes, yes.
Then item number 2, a decision on the issue raised by majority leader.
Yes.
Whether this answer you supplied us with is fake
yes,
or offensive.
yes.
And then number 3
yes,
is you also promised that you are going to make a determination
yes,